This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's a war, man.
That's Todd Blanche, the second in command at the Justice Department, saying the department is at war with federal judges. Blanche echoed President Donald Trump and Attorney General Pam Bondi's attacks on so-called rogue judges who handed down decisions against the Trump administration.
These activist judges that they have a robe on, but they are more political, or certainly as political, as the most liberal governor or DA.
The Deputy Attorney General, who was formerly Trump's lawyer, defended the Justice Department against claims of weaponization, but then urged young lawyers to join the war against judges.
There has got to be a couple dozen young lawyers who are thirsty and hungry and ready to work because we need you because it is a war.
A group of retired federal judges is warning that the language Blanche used poses a grave threat to the rule of law and the judiciary. Joining me from the Article 3 Coalition is Judge Johnny Jones III. He was appointed by George W. Bush and served for 2 decades on the U.S. District Court for the Middle District of Pennsylvania. Judge Jones, first, your reaction to the Deputy Attorney General saying that the Justice Department is at war with the judiciary.
I think that the comment is at minimum inopportune, and I think writ large, it's grossly irresponsible for the number 2 individual at the Department of Justice to characterize anything involving the federal judiciary as a war against so-called rogue judges. It is highly problematic, and I think it's causing a great deal of consternation among the judiciary, not just active judges, but retired judges as well.
He said, we have judges literally telling the president, the executive, what he can and cannot do. We have seen judges not following the law and the Constitution. And he said they have a robe on, but they are more political, or certainly as political as the most liberal governor or DA.
Well, June, here's a news flash. That's exactly what judges are supposed to do, is say what the law is. They've been interpreting the law, of course, since Marbury versus Madison. And I think he's protesting too much. What he's really striking out against are decisions that are, in the judge's view, in accordance with the law and legal precedent. Simply because you disagree with the decision doesn't mean that you're at war with the judge who made the call. The government is fully able to exercise its appellate rights, and in fact, they have in any number of these cases. So, to say that judges are political simply because they rendered a decision that you don't agree with is really a baseless allegation. I guess red meat, if you will, for the conservative lawyers in the Federalist Society, but I would suspect that a lot of those lawyers, entertained though they may have been, know better.
So his target was sort of on the district court judges, the trial court level. And he said that when it gets to the Supreme Court has reversed them except for 1 or 2 times, which is true. But that assumes that the conservative majority on the Supreme Court is right and the federal district judges are wrong. And these decisions were all made on the emergency docket without full briefing or oral arguments.
Well, a couple of things I'd say about that. There are far more decisions that are standing than ones that are appealed to the Supreme Court. As you know, that court has a discretionary docket. So some of these lower court decisions have stood up simply because the Supreme Court hasn't taken them. Now, it is noteworthy that the Supreme Court has placed on its emergency docket a number of different cases. And yes, the government has been successful. I don't know that it's necessary under the circumstances for Mr. Blanche, to be a sore winner and do a sort of victory dance about that and castigate lower court judges. The Supreme Court gets the final word on these cases, but I can go over any number of cases that district courts have heard and have indicated that those decisions are in accordance with precedent and the law under the circumstances. These are close questions in some cases as well. But again, this sort of sore winner thing is pretty wearying and unbecoming. Again, I'd say the Department of Justice that I knew and worked with was very professional during my nearly 2 decades on the federal bench.
The number of threats against federal judges have skyrocketed, as you know. What does it do when you have the second in command saying things like this, saying, we're at war, saying that judges are not following the law, they're not following what the Supreme Court says? What's the effect when the general public, who may not know about the underlying cases, hears something like that from the number 2 person at Justice?
Well, you have to take it in concert, June, with what's been happening for this entire year since January 20th, which is that judges are being singled out by name. Their families are being singled out. They're being doxxed. Anybody can find the location of a judge, even though there's been legislation to redact and hide some of their personal information. And I think fairly, judges are frightened. It puts a bullseye on judges. And you correctly cite the U.S. Marshal Service as indicated that threats against judges, there were 500 plus bona fide threats in the last fiscal year, and they're growing exponentially. I've always said that, there are a lot of people that disagree with judges' decisions. That's the nature of the business. But it's that small percentage of unbalanced people who kind of hear this as a dog whistle. And I have said for years, because of this inflammatory rhetoric, that we're going to get a judge hurt or killed. You need only look back at my former colleague Esther Salas's tragedy, where her son Danny was shot and killed back in 2020. I fear that's going to happen again if we don't dial down the rhetoric. Again, this goes to the irresponsibility of Mr. Blanch's comments. We need to level set here instead of making it worse.
And to put this in context, these weren't casual remarks, because we've heard similar remarks from the Attorney General, Pam Bondi. She's actually called out individual judges by name for their decisions, and of course, so has President Trump. Is there some kind of strategy at play here by the Justice Department? Are they trying to scare judges? What's at play?
Well, if they're trying to scare judges, that won't work, because I think fairly my friends and former colleagues in the judiciary are not easily frightened. Sure, there may be a motivation to have them look over their shoulders. I think what it is it tears down the integrity of the judicial system. All 3 branches, I think, at bottom have a responsibility to uphold the integrity of their existence as co-equal branches of government. We are seeing this unitary president going wild now. There's another problem here, June, and I think it's that we are losing any line of distinction between the president and the Department of Justice. Of course, I'm not naive. There's always some interaction between the president and the Department of Justice, but they've almost become one and the same, which I think is truly troubling. So this is the number 2 man and, in fact, the Attorney General doing the bidding for the President of the United States and simply parroting his view of federal judges and carrying out, we know this now because we've seen, some of the things that the president has written and thought that he was playing to an audience of, for example, General Bondi, and instructing them to prosecute people. I think my conservative lawyer friends, for example, who listen to Todd Blanche ought to be careful what they wish for, because in a world like that, I don't think anybody is particularly safe.
And Blanche denied that the Justice Department was being weaponized. And he said the department was weaponized before, during the Biden administration. Then he talked about the prosecutions of President Trump. However, he did not mention that the current Justice Department is prosecuting former FBI Director James Comey and New York Attorney General Letitia James.
My response to that, June, is there was a statement made by the New York Bar Association criticizing Blanche, and his response was LOL to that. Well, my response to what Mr. Blanche said about weaponization is LOL. It's the same thing. If this isn't weaponizing the Justice Department, people may disagree or agree about weaponization during the Biden administration. I'm talking about the here and now. I don't think we've seen as stark a weaponization of the Department of Justice ever. Think about the DOJ as it participated in the efforts, the executive orders against law firms. They litigated those cases. It was lawyer on lawyer through that. Think about Mr. Blanche traveling to federal prison to see Ghislaine Maxwell and getting a statement from her. We know now that he probably had access to emails that directly contradicted what she apparently told him, looking like every bit the president's personal lawyer instead of the number 2 man at Justice. We're in a world that is vastly different than anything I've ever seen in terms of the interaction between the Justice Department and the courts. When I was a judge, by the way, I thought federal judges had pretty enormous power to be used very sparingly and carefully. We're now living in a time when essentially the President of the United States and the Department of Justice, they're saying in as many words, just disregard district court judgments. They're not worth, the electronic ink that's being used to render them. I don't think that that's helpful or appropriate in any way in terms of the integrity of the third branch of government.
He didn't just attack judges. He also attacked the bar associations, and he vowed to take away the bar association's oversight power. Now, complaints have been filed against Justice Department lawyers with bar associations, but does the Justice Department have any power over that?
I confess, June, to confusion as well about how that could be accomplished, because you're a member of a bar association, and, for example, the Pennsylvania Bar Association polices its own, and they can suspend you. The Supreme Court of Pennsylvania can get involved and suspend your right to practice for a period, or they can disbar you. So good luck with that. Not only is it, I think, an overreach from a rhetorical standpoint, but I think it's mission impossible.
And tell us why the Article 3 coalition decided it had to issue a warning about Blanche's statements.
This is something that we feel in unanimity that is really injurious to the rule of law. And, if you can get 50 retired judges, thoughtful, appointed by different presidents, folks of different viewpoints going the same direction like this, you've got something that is really, really problematic. And, I was proud to join that group. I fear it's going to get worse before it gets better, and that's really troubling.
Thanks so much, Judge Jones, for sharing your insights and concerns with us. That's Judge John E. Jones III. Coming up next, another setback for transgender rights at the Supreme Court. I'm June Grasso, and you're listening to Bloomberg. It's the 24th win for the Trump administration and the second blow to transgender rights on the Supreme Court's emergency docket in the last 6 months. It was a vote down ideological lines, and the court's conservatives are allowing the Trump administration to require that passports be marked with a person's sex assigned at birth. This is a reversal of the policy that's been in place since 1992, which allowed passports to reflect a person's gender identity. But President Trump made it clear when he was campaigning that he would reverse transgender rights.
With the stroke of my pen on day one, we're going to stop the transgender lunacy. And I will sign executive orders to end child sexual mutilation, get transgender out of the military and out of our elementary schools and middle schools and high schools.
And back in May, when Trump issued a transgender military ban, the Supreme Court's conservatives allowed him to discharge thousands of transgender service members who'd been serving openly for years. My guest is Suzanne Goldberg, a professor at Columbia Law School and director of the school's Sexuality and Gender Law Clinic. Suzanne, will you explain the change in passport policy by the Trump administration?
For 33 years, across 6 presidential administrations, transgender Americans have been able to get U.S. passports with their gender marker that accurately matches their gender identity. So a transgender man can get M on his passport, and a transgender woman can get a F on her passport, which is important for many reasons, including so that the person looks like they match their passport. From basically 1992 to 2010, there was an eligibility requirement related to a surgical transition that has changed over time. The point is, for 33 years, this has been the same. But on the first day of his administration, Donald Trump issued an executive order saying that transgender people are corrosive to the United States in so many words. He used the word corrosive, and directing the State Department to no longer issue passports to people that would be consistent with their gender identity if they're transgender. And so the Trump executive order led the State Department to take 2 steps. First, to stop issuing passports to transgender people consistent with their gender identity. And second, to remove the X gender marker, which was an option for anyone who does not fit the M or the F, or someone who doesn't want to share their gender identity with the U.S. government. So put into simple terms, The Trump administration changed policy on the first day of the administration, and the State Department followed 2 days later to prevent transgender Americans from obtaining passports consistent with their gender identity.
This was an unsigned order, and the conservative justice's very short explanation seems to me like it's ignoring the facts that were presented in the case. The justices said, displaying passport holders' sex at birth no more offends equal protection principles than displaying their country of birth. In both cases, the government is merely attesting to historical fact without subjecting anyone to differential treatment.
It is stunning because the plaintiffs in the case explained to the district court, which agreed, as did the Court of Appeals, that if you are a transgender man and you have a passport that says F on it, it does have real-world harmful consequences every time you have to show that passport to someone, because the person receiving the passport may say, as has happened to some of the plaintiffs, you're using fraudulent documents because you don't appear to match your passport gender marker. So this has led to some of the plaintiffs being accused of fraud, one of the plaintiffs being strip searched, other plaintiffs facing all sorts of problems as they've tried to cross borders. So for one, the Supreme Court's kind of casual remark that this is as insignificant as somebody's sort of national origin or place of citizenship is just untrue. In addition, the country of birth is not anything that affects somebody when they're using their passport and passing through security. But the gender marker is used to check accuracy. And so even on its face, the Supreme Court's analysis is wrong. The Supreme Court's description, I can't really call it analysis. The Supreme Court statement is wrong. And a dissent from Justice Jackson points that out as well.
The court also found that the administration is likely to win on the merits, and the administration faced irreparable injury. I'm not sure where the irreparable injury is, since this policy is a new one that's changing what's been in place. But the conservative justices have found irreparable injury in almost all of President Trump's emergency requests.
There is no irreparable injury in the traditional way that courts look at irreparable harm. So let me explain. When a statute comes over from Congress and is challenged in the court, it is given a presumption of constitutionality. Right? So the court assumes it's constitutional, but sometimes plaintiffs can show actually it's unconstitutional and the court will strike it down. And there's understood to be some arguable harm to government when a statute is put on hold. But when a government policy is put on hold, like an executive order or a preference of the president, that's a different situation. That is not entitled to the same presumption of constitutionality as a statute that has been passed by Congress. And the upshot is just saying, well, the government is irreparably harmed by not being able to put in place its desired passport policy is akin to saying the government is irreparably harmed whenever it is stopped from doing something that it would like to do. And that is akin to having no judicial review over government actions at all, at least not at this preliminary stage. So that's a very serious problem from a sort of basic approach to constitutional analysis of executive actions.
Justice Jackson wrote that the court has once again paved the way for the immediate infliction of injury without adequate or really any justification. This is also a pattern of the court at this point, basically allowing the Trump administration anything it asked for on the emergency docket and saying, well, this is while litigation is pending.
Yes, this is the 24th consecutive grant of emergency relief to the government. And this process of the Supreme Court staying rulings of lower courts, finding constitutional or other problems with government policies, this phenomenon of the Supreme Court repeatedly saying, oh, we're going to put those lower court rulings on hold, has had the effect of basically giving the Trump administration a free pass to continue enforcing policies and taking actions that lower courts have held to be not only likely unconstitutional, but also causing irreparable harm to the people who have been affected. So this is certainly part of a larger trend The striking thing about this case is that the harm to the individuals who are denied passports that accurately reflect their gender identity is stunningly clear. Another problem here is that the government is obligated, anytime it changes a policy that collects information from the American people, the government is obligated under the Paperwork Reduction Act, which was passed by Congress, to spend 60 days collecting information and public comment on whether it can make this sort of a change. And of course, changing its passport rule 2 days after the president was inaugurated and issued his executive order is fully out of compliance with this law that is supposed to apply to all of the government's actions.
As I mentioned, this order stays in place as the litigation below continues. So how much of a blow is it to the rights of transgender people?
This is a tremendous blow in terms of the human cost. One only has to think about the named plaintiff, Ashton Orr, who needed to travel out of the country, needed a new passport. Ashton Orr is a man. He's a transgender man. The only passport he is able to get to cross borders has an F gender marker on it. That reveals Ashton to be transgender not only as he crosses the border out of the United States, but as he crosses into other countries, possibly putting him in danger of harm from other governments and now as well as our own. The harms are very serious, very painful to individuals, and also are reflective of a broader harm to people who are not transgender, which is that the government can, for irrational reasons, possibly hostile reasons toward this group of people, or any group of people more generally, choose to withdraw a passport, right? Choose to do any number of things that cause harm, and the Supreme Court is unwilling to say, hold on, government, the lower court has found a problem with this law or this new policy, and we need to hold while this case is being litigated. So there are real-world problems, there are constitutional problems, there are traditional separation of power problems that we're seeing.
In May, the Supreme Court allowed Trump to discharge transgender people serving in the military. In June, the court upheld a Tennessee law that bans gender-affirming care for minors. And now the court is allowing this passport policy to go into effect. In all these cases, the conservatives were in the majority and the liberals in dissent. It's hard to ignore that the court has been ruling against transgender rights, at least since a case in 2020.
Yeah, I mean, there has been a torrent of policies, from the Trump administration and laws at the state level that restrict the lives or try to restrict the lives of transgender people in every imaginable way, from getting identity documents to using the bathroom to participating fully at school to serving the country in the military. And so far, when these issues have been presented, the court has said it's okay to create this legal barrier, really like a legal burden that harms transgender people. In 2020, the court took a different tack. This involved an employment discrimination case. A transgender woman was fired from a role at a funeral home where she had served for many years, and she sued the employer, saying it was sex discrimination, that she was treated differently because of her sex, being fired based on that she is transgender. And in that case, Bostock versus Clayton County, which also involved two other cases with sexual orientation discrimination at issue, in that case, the court said it is sex discrimination to fire a transgender person because there's no way to understand this other than they're being fired because of their sex. One of the big questions before the court is that case came under Title VII, which is a federal law that prohibits sex discrimination, as well as other forms of discrimination in employment. And a question is whether the logic of understanding sex discrimination in that Bostock ruling from 2020 is going to carry over into these other areas, or will the court say, as it may appear to be inclined to do, oh, no, that might be sex discrimination, but this isn't.
We'll see if the pattern holds or not, because in January, the court is going to hear arguments on whether states can ban transgender girls and women from competing on female athletic teams. Thanks so much, Suzanne. That's Columbia Law School professor Suzanne Goldberg. Coming up next, the conservative justices appear skeptical of a Rastafarian's religious liberty suit. I'm June Grasso, and you're listening to Bloomberg.
It is undisputed that my client has alleged an assault that is just brazenly illegal. He was at respondents' mercy in federally funded custody when he handed them a copy of controlling precedent holding that RLUIPA protected his right to keep his hair long. They threw it away, handcuffed him to a chair, and shaved him bald.
Damon Landor is a devout Rastafarian who hadn't cut his hair for nearly 20 years, following his faith in which dreadlocks are a sacred symbol. When Landor was transferred to a new prison in Louisiana with just weeks left on his 5-month sentence, he handed a prison guard a copy of an appeals court decision that held that cutting a religious prisoner's dreadlocks violated federal law. The guard threw the ruling into the trash. And despite Landor's pleas, he was handcuffed to a chair and held down by 2 guards while a third cut his knee-length dreadlocks and shaved his head. No one disputes the glaring violation of his religious rights, as Justice Amy Coney Barrett noted.
Look, the facts of this case are egregious. So if on the facts we were looking for a case in which there should be money damages, this is it.
But it's not just about the facts. It's about the law and whether Landor can sue the guards and prison officials for damages under the Religious Land Use and Institutionalized Persons Act, better known as RLUIPA. The Supreme Court has repeatedly sided with religious litigants, but a majority of the conservative justices, led by Justice Neil Gorsuch, appeared skeptical that Landor could sue for damages.
The circuits are unanimously against you and have been for many, many, many years. So saying that something awful is going to happen, it's all, whatever's happened has happened, right?
And the conservatives questioned whether the prison guards had been given proper notice that they could be held personally liable. But the liberal justices said it was clear that the guards understood that. Here are Chief Justice John Roberts and Justice Sonia Sotomayor.
If you're hired as a prison guard in Louisiana, you don't sit down, and I don't even know if Louisiana does, saying, here's our agreement with the federal government, which probably goes on for I don't know how many pages. And you should look at it carefully because you're bound by it.
Generally speaking, if you're a prison official, you know you're working in a prison and you're bound by law to pay damages if you violate the law. Do you get an out because what?
My guest is John Meiser, a professor at Notre Dame Law School and director of the school's Religious Liberty Clinic. John, tell us about the law that Landor is suing under.
That act, which shorthand is called RLUIPA, was passed in 2000 in conjunction with an act that was passed a few years earlier, the Religious Freedom Restoration Act. And both of them sort of target the same goal, which is to, as a matter of federal statutory law, to restore a more robust set of protections for religious exercise, which previously had been available under the U.S. Constitution, but then a seminal case in 1990 sort of restricted some of those rights as a matter of constitutional law, and then Congress acted to restore them as a matter of statutory law.
So RLUIPA was designed to protect the religious rights of inmates. What's the problem with Landor using it here?
So RLUIPA focuses on 2 areas of state and local government activity. One is in land use, decisions about how you can use your property. And then the one relevant here is about religious exercise in jails and prisons. And so there's no doubt that the law, RLUIPA, protects Mr. Landor's rights here. He's a state prisoner, and so therefore safeguards his right while incarcerated to exercise his religion. And the only question in this case is one of remedies. So the facts are egregious. I don't think anyone really doubts that while he was in prison, his rights were blatantly violated. He's a Rastafarian, which among other things requires him not to cut his hair. He actually had a judicial decision when he entered the prison that held the prison's policy requiring, they normally require forced shaving of all the inmates' hair. He had a decision saying that couldn't be enforced against Rastafarians like him, but the guards literally threw away that decision, handcuffed him to a chair, and shaved his head anyway. So there's no doubt his rights were violated, and the question now is only, what sort of remedies does RLUIPA allow for him to address that violation?
Justice Ketanji Brown Jackson read from RLUIPA and said, it seems pretty clear. And 5 years ago, the Supreme Court unanimously ruled that the sister statute, the Religious Freedom Restoration Act, permits money damages against federal officials In that case, Muslims were allowed to sue over their inclusion on the FBI's no-fly list. So why doesn't that analysis work for the law here, RLUIPA?
Yeah, so the legal question at the heart is a pretty technical one of congressional power. So what both RFRA and RLUIPA, what these laws allow is for someone who's been injured, whose rights have been violated, to file a lawsuit in federal court against those who caused the violation. The statute, the words of the law, allow you in that lawsuit to get all appropriate relief. So then the whole question becomes, well, what does Congress mean by appropriate relief? One thing that's undisputed is appropriate relief certainly includes a judicial order that would prevent an ongoing violation of religious rights. So if the jail were continuing to threaten to violate Mr. Landor's rights, say they were shaving his head every week, you could get a court order telling them to stop doing that. The question, though, is, as you just touched on there, is, well, what about one-time harms? What about harms that aren't ongoing? They're over now. How do you remedy those? Does the law allow you to get monetary damages, which would be the normal way in a lawsuit? If you've been harmed, the normal recourse in the law is you're able to get monetary damages, get money to help in some way remedy or repair that harm. But the question here is, does RLUIPA allow that? You're right. RFRA, the sister statute, was held to allow monetary damages. And the question of, well, does RLUIPA allow the same, turns out a very particular idea of the congressional power at issue here, which is Congress's use of its spending power. Does the spending clause require something more for a statute to authorize monetary damages? Does appropriate relief clearly enough convey that when a state accepts federal spending, it might open itself up or open its officers up to suits for money damages?
Did it seem fairly apparent that most of the conservative justices thought that Landor couldn't sue for money damages under the statute?
I don't know how clear it is, but I do think a number of justices certainly expressed skepticism about that. There's a couple different things going on. One is, what does the statute mean? What does appropriate relief mean in context of laws like this? The statute itself, is it clear enough that it allows monetary damages? And then the other is, well, okay, even if it is, does the Constitution let Congress do that through a spending clause law like this? And several justices, I think, expressed some skepticism on one or both of those questions, but I think the skepticism all came back to a similar idea, which is spending clause legislation opens up money for state governments to take part in federal programs or to receive federal subsidies for different types of things here, jails and prisons. And the federal government can attach conditions to those. And the court's concern is that states are coming into that bargain with their eyes open, that they understand the conditions they're agreeing to. It's one of notice. I don't think it's so much about whether it would make sense to apply these substantive religious rights in prison. And everyone agrees, actually, that the prison and its officials are bound substantively to protect the rights that RLUIPA demands. But what some of the justices in the court were really struggling with was, how clear was it? Were individuals who work within those prisons really on notice that by signing up to work in the prison, they might be sued for things like this?
It seemed like a lot of the conservative justices didn't think that there was notice here. At one point, Chief Justice John Roberts said, it's a legal fiction to say that a prison guard knows what he's signing up for here. But the liberals, particularly Justice Sotomayor, said, when you sign up to work as a corrections official in a prison, doesn't that mean you're signing up to obey the law? And, the act here was so obviously brutal, and the guard took the law that was handed to him and not only ignored it, but threw it in the garbage.
I agree with that, and I think Mr. Landor has a very good argument here, right? So it's of course true, as the Chief Justice pointed out, that there's something of a legal fiction here. But that's, these legal fictions run throughout the law. We're all presumed to have knowledge and be aware of the contents of criminal law. Is any given person on the street actually aware of everything that's prohibited by federal or state criminal law? No, of course not, right? But ignorance of the law, even if actually true, we don't allow that ignorance of the law to be an excuse to defy it, right? And so, Justice Sotomayor's point here, which is echoed throughout the argument by Mr. Landor's counsel, is that at least in this context, where we're talking about people who sign up to work in a prison or a jail, these officers, we all the time presume they understand their obligations under federal law, under constitutional law, under state law, and they understand that if they violate those obligations, these demands that they protect our rights, that they might be sued for it. And again, I don't think there's any doubt in the case, and I think the state actually concedes that as a substantive matter, the state and its officers were bound to follow the demands of RLUIPA. So then the only question is, well, they knew they had to follow RLUIPA, they knew they could get sued under RLUIPA, they knew they could be held subject to injunctive relief under RLUIPA, do they also need to know that they could be sued for money under RLUIPA? Well, even if that's a separate question, I agree with Mr. Landor here that it's not a very hard one because, again, as soon as you're understanding that you might be sued as an individual, the normal recourse is that if you're found to have violated the law, you might have to pay money damages.
And do you have a feel for how the court might come out in this case?
No, I don't have a feel. I mean, I think it's a complicated case. It was obvious to me that in the argument, a lot of the justices were really struggling with how to draw these lines and these concerns over notice and keeping Congress from overstepping its enumerated powers, which itself is a rights protecting idea typically, but with the recognition that here is a seminal piece of legislation to protect religious freedom, a piece of legislation the court has repeatedly been sure to safeguard and uphold. And I think there's real tensions with how best to weigh those, competing sort of priorities of the court. So I do think the case is harder than it might appear at first blush, but I also would hope that the court would ultimately align the reading of the two statutes, and it would be at least a somewhat unusual result if RFRA and RLUIPA, these sister statutes passed for the same purposes, allowed different remedies, and it would leave people like Mr. Landor without any recourse to remedy what all agree was an egregious violation of his rights. And it would leave no ability to hold the individuals who literally threw away a copy of a court decision and to hold them accountable. And I think that would be regrettable, certainly.
I admit I initially thought that the court took this case to reverse the lower courts and allow Landor to sue for damages, especially considering how solicitous the justices usually are about protecting religious liberties. And the facts here, how often do you have the plaintiff showing the law to the defendant and the defendant just tossing it out? You can't make these things up.
I mean, I agree. And I think at the end of the day, the simplest reading of the case is what you're saying. This is a blatant violation of this man's rights. It doesn't seem real. They literally threw away the decision. They handcuffed him. They forcibly shaved him. And now the claim is brought under a law that's nearly identical to one that the court just said allows lawsuits for damages like this. Simplest thing is, you take it to reverse and to make clear, yes, RLUIPA is just like RFRA. It allows these damages. And I think that's the right outcome. I do agree, though, that from the argument, it seems the court is certainly struggling with more complications than that.
Thanks so much, John. That's Professor John Meiser of Notre Dame Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.